In this recording, we're going to read Giles versus California. Okay. Actually, let's introduce the topic. Declarations against interest as an exception to the hearsay rule. Unlike the admissions doctrine, the exception for declarations against interest applies to statements by anyone, not just statements made by or attributable to the party against whom they are introduced. But again, unlike admissions doctrine, the present exception applies only to statements that are obviously contrary to the interest of the declarant. So contrary, in fact, that a reasonable person would make this statement only if it were true. Period. The major controversies associated with this exception have concerned its application to declarations that appear to subject the declarant to criminal liability. The advisory committee note to Federal Rule of Evidence 804b3, which is again declarations against interest of the declarant, reads as follows. The circumstantial guarantee of reliability for declarations against interest is the assumption that persons do not make statements which are damaging to themselves unless satisfied for good reason that they are true. If the statement is that of a party offered by his opponent, it comes in as an admission. Rule 801d2. And there is no occasion to inquire whether it is against interest. This is not being a condition precedent to admissibility of admissions by opponents. The common law required that the interest declared against be pecuniary or proprietary, but within this limitation demonstrated striking ingenuity in discovering an against interest aspect. The exception discards the common law limitation and expands to the full logical limit. One result is to remove doubt as to the admissibility of declarations tending to establish a tort liability against the declarant or to extinguish one which might be asserted by him in accordance with the trend of the decisions in this country. Another is to allow statements tending to expose declarant to hatred, ridicule, or disgrace, the motivation here being considered to be as strong as when financial interests are at stake. And finally, exposure to the criminal liability satisfies the against interest requirement. The refusal of the common law to concede the adequacy of a penal interest was no doubt indefensible in logic, but one senses in the decisions a distrust of evidence of confessions by third parties offered to exculpate the accused arising from suspicions of fabrication either of the fact of the making of the confession or in its contents, enhanced in either instance by the required unavailability of the declarant. The requirement of corroboration is included in the rule in order to effect an accommodation between these competing considerations. When the statement is offered by the accused by way of exculpation, the resulting situation is not adapted to control by rulings as to the weight of the evidence, and hence the provision is cast in terms of a requirement preliminary to admissibility. The requirement of corroboration must be construed in such a manner as to effectuate its purpose of circumventing fabrication. Ordinarily, the third-party confession is thought of in terms of exculpating the accused, but this is by no means always or necessarily the case. It may include statements implicating him, and under the general theory of declarations against interest, they would be admissible as related statements. Whether a statement is in fact against interest must be determined from the circumstances of each case. Thus, a statement admitting guilt and implicating another person made while in custody may well be motivated by a desire to curry favor with the authorities and hence fail to qualify as against interest. On the other hand, the same words spoken under different circumstances, i.e. to an acquaintance, would have no difficulty in qualifying The rule does not purport to deal with questions of the right of confrontation. And lastly, as an introductory explanation of what is meant by the declarations against interest, we read the report of the House Judiciary Committee in 1974. So the court's rule proposed to expand the hearsay limitation from its present federal limitation to include statements subjecting the declarant to criminal liability and statements tending to make him an object of hatred, ridicule, or disgrace. The committee eliminated the latter category from the subdivision as lacking sufficient guarantees of reliability. As for statements against penal interests, the committee shared the view of the court that some such statements do possess adequate assurances of reliability and should be admissible. It believed, however, as did the court, that statements of this type tending to exculpate the accused are more suspect and so should have their admissibility conditioned upon some further provision ensuring trustworthiness. The proposal of the court to add a requirement of simple corroboration was, however, deemed ineffective to accomplish this purpose, since the accused's own testimony might suffice while not necessarily increasing the reliability of the hearsay statement. The committee settled upon the language, unless corroborating circumstances clearly indicate the trustworthiness of the statement, as affording a proper standard and degree of discretion. So, let me just see. The advisory committee note to this federal rule of evidence doesn't have a date. It almost is reconcilable with the report of House Judiciary Committee. So I want to say this pertains to an amendment to that section, but this is just much easier to read. I feel like I'm getting the definition here, which is include statements subjecting the declarant to criminal liability. And it looks like they end it there and no longer want to limit or to include statements tending to make him the object of hatred, ridicule, or disgrace, which is why it sounds unreconcilable. But the statements of that subject the declarant to criminal liability ought to be corroborated, unless corroborated is down here, and then everything in between talks about exculpatory property to the accused. So just checking to see if the purpose of the rule, according to United States v. Duran Samaniego, which I actually have to read this case. So we're going to read this case before we read Giles. Between 1972 and 1989, Robert Duran Samaniego won 4 world boxing championships. He retired in 2002. Duran claims that his championship belts were stolen from his house in Panama by his brother-in-law, Bolivar Iglesias, in September of 1993. It is undisputed that Duran's championship belts ultimately came into the hands of Luis Gonzalez Baez, a Miami businessman, and that Baez attempted to sell the belts to undercover FBI agents who had set up a sting operation for $200,000. Baez was arrested, but he claimed that the belts had not been stolen. The government confiscated the belts and filed an interpleader action in federal court to determine whether Duran or Baez is the rightful owner of the belts. The case was tried to a jury, which returned a verdict in favor of Duran. This is Baez's appeal from the judgment the district court encountered in accordance with that verdict. Baez's principal contention on appeal is that the district court, so those are all the facts, but here's more so the contention. The district court should not have admitted testimony about the purported apology from Bolivar Iglesias. Over Baez's objection, the district court permitted a number of witnesses, including Duran and some of his family members, to testify that Iglesias apologized in the presence for stealing the belts. Baez contends that testimony is inadmissible hearsay. The district court allowed it on the theory that the out-of-court statement described an existing state of mind or emotion, and for that reason fit within the hearsay exception set out in the Federal Rule of Evidence 8033. What is that supposed to be? Excited utterance? Just plain old state of mind. Okay. The question, as Baez's argument frames it, is whether Iglesias' apology falls into the exclusion from 8033 admissibility because it is a statement of memory or belief to prove the fact remembered or believed. So there's that. And then an apology is evidence of a then existing state of mind or emotion, remorse. Iglesias' apology is admissible to prove the truth of the matter asserted, and that Iglesias felt remorse at the time he made the apologetic statement. That is not the problem. The problem is that the state of mind exception does not permit the witness to relate any of the declarant's statements as to why he held a particular state of mind or what he might have believed that would have induced the state of mind. Okay, from U.S. v. Cohen, 1980. The purpose of the exclusion from Rule 8033 admissibility is to narrowly limit those admissible statements to declarations of condition. I'm scared, and not believe I'm scared because someone threatened me. The condition admitted in this case was not limited to the fact that Iglesias had expressed remorse, but also included the fact that he said he apologized for and asked for forgiveness for having stolen the belts. The testimony was most often came in response to questions from Duran's counsel about how the witness knew Iglesias had stolen the belts. What Iglesias said was offered to show not only that he was remorseful, but also that he had stolen the belts. Rule 8033 expressly prohibits the use of a statement of then existing state of mind in this way. That prohibition, the committee notes, explains, is necessary to avoid the virtual destruction of the hearsay rule, which would otherwise result from allowing state of mind, provable by a hearsay statement, to serve as the basis of an inference of the happening of the event which produced the state of mind. Our conclusion that Iglesias' apology was not properly admitted under this rule does not end the matter. Although the district court admitted the statement under that rule, Duran offered the testimony concerning the apology as a statement against interest. So here's where we get to the proper hearsay exception by a declarant unavailable at trial, which is admissible under Rule 804b3. The district court did not reach this alternative ground for admissibility, but we do because we will not hold that the district court abuses discretion where it reached the correct result, even though it did so for the wrong reason. The part of Iglesias' apology in which he admitted having stolen Duran's belts is a statement against interest because it would subject the declarant to civil or criminal liability within the meaning of the rule. For a statement against interest to become available or admissible under 803, however, the declarant must have been unavailable at the time of the trial within the meaning of 804A. Iglesias was not present at the trial, but that does not mean he was unavailable for 804 purposes. Section A of that rule tells us a witness so he need to be unavailable. Okay. Something tells me we're gonna remand this. Okay, just keep reading. Subsection A of that rule tells us witness should be considered unavailable in 5 separate circumstances. So, let's read them. Only one of which is relevant in this case. The declarant is unavailable if he is absent from the hearing and the proponent of a statement has been unable to procure the declarant's attendance, or in the case of hearsay exception under B2, B3, or 4, the declarant's attendance or testimony by process of another reasonable means. Duran could not procure Iglesias' attendance or testimony by process because Iglesias is in Panama, apparently was living in that country at the time of the trial, and foreign nationals located outside the United States are beyond the subpoena power of the district. Unavailable. That's from U.S. v. Strogel. of 1993, Duran did enlist the help of Iglesias' immediate family in an attempt to locate him and persuade him to return to the United States to testify. Iglesias' sister, who was Duran's wife, testified that she and her mother had tried to locate Iglesias on 5 different occasions, but finding him had proven impossible. So they tried. Iglesias' mother testified that she had tried to contact him in order to get him to come back and testify, but was unable to get Iglesias. Using the efforts of Iglesias' sister and mother, as Duran did, as a reasonable means of attempting to locate Iglesias in Panama and persuade him to travel to the United States to testify. It follows that Duran did establish Iglesias was unavailable to testify under Rule 804A5, so the out-of-court statement Iglesias made was admissible under that rule, or under 804B3 as a statement against interest. The district court did not abuse its discretion by admitting the statement, albeit the wrong ground. The judgment stands, and Roberto Duran is entitled to regain his championship belt. So that's a conclusion. So you guys are at 15 minutes. Let's just see how long Giles. Oh, yeah. Giles versus California is kind of long. Not really. I'm just going to read the majority opinion. Might take me 10 minutes. This is a 2008 case given, a majority opinion given by Justice Scalia, delivered the opinion in court. Dwayne Giles fatally shot his ex-girlfriend Brenda Ave. A jury convicted him of murder, rejecting his claim of self-defense. Among the evidence at trial were statements that Ave had made to a police officer responding to a domestic violence report about 3 weeks before the shooting. Ave, who was crying when she spoke, told the officer that Giles had accused her of having an affair, and that after the two began to argue, Giles grabbed her by the shirt, lifted her off the floor, and began to choke her. According to Ave, when she broke free and fell to the floor, Giles punched her in the face and head, and after she broke free again, he opened a folding knife, held it about 3 feet away from her, and threatened to kill her. He found her cheating on him. Over Giles' objection, the trial court admitted these statements into evidence under a provision of California law that permits admission of out-of-court statements describing the infliction or threat of physical injury on declarant when the declarant is unavailable to testify at trial, and the prior statements are deemed trustworthy. So that's what the trial court said, but it's also a California law. Evidence Law 1370. The state does not dispute here, and we accept without deciding that Ave's statements accusing Giles of assault were testimonial. But it maintains, as did the California Supreme Court, that the Sixth Amendment did not prohibit prosecutors from introducing the statements because an exception to the confrontation guarantee permits the use of the statement's unconfronted testimony if a judge finds, as the judge did in this case, that the defendant committed a wrongful act that rendered the witness unavailable to testify at trial. We held in Crawford that the Confrontation Clause is most naturally read as a reference to the right of confrontation at common law, admitting only those exceptions established at the time of the founding. We therefore ask if the theory of forfeiture by wrongdoing accepted by the California Supreme Court is a founding era exception to the confrontation right. We have previously acknowledged that 2 forms of testimonial statements were admitted at common law even though they were unconfronted. The first of these were declarations made by a speaker who was both on the brink of death and unaware he was dying. That's from King v. Woodcock of 1789. Ave did not make the unconfronted statements admitted at Giles' trial while she was dying, so her statements do not fall within this historic exception. The second common law doctrine which we will refer to as the forfeiture by wrongdoing, permitted the introduction of statements of a witness who was detained or kept away by the means of procurement of the defendant. The terms used to define the scope of the forfeiture rule suggest that the exception applied only when the defendant engaged in conduct designed to prevent the witness from testifying. We are aware of no case in which the exception was invoked, although the defendant had not engaged in conduct designed to prevent a witness from testifying, such as offering a bribe. In cases where the evidence suggested that the defendant had caused the person to be absent, but had not done so to prevent the person from testifying, is in the typical murder case involving accusatorial statements by the victim, the testimony was excluded unless it was confronted or fell within the dying declaration exception. Prosecutors do not appear to have even argued that the judge could admit the unconfronted statements because the defendant committed murder for which he was on trial. So, I mean, I get this. They're analogizing, I guess, like a protection from abuse order, which this, oh wait, Abe's dead. Abe's dead. Okay, so when you shoot a person and that's why they can't show up, you forfeit your right to not have a testimonial statement by that person brought in against, you forfeit your confrontation clause right by your wrongdoing of killing that person, which you're not really guilty of that yet, so this is tough. This is really tough content. But anyways, the testimony was excluded unless it was confronted or fell within the dying declaration. Prosecutors do not appear. Okay, so they didn't argue that in that particular case. But that is a... Okay. I don't know what case that was. We don't have a case name here. Which is rare. Consider King versus Woodcock. William Woodcock was accused of killing his wife Sylvia, who had been beaten and left near death. A magistrate took Sylvia Woodcock's account of the crime under oath, and she died about 48 hours later. The judge stated that great as a crime of this nature must always appear to be, yet the inquiry into it must proceed upon the rules of evidence. Aside from testimony given at trial in the presence of the prisoner, the judge said there were two other species which are admitted by law. The one is the dying declaration of the person who has received a fatal blow, and the other is the examination of a prisoner and the depositions of the witness who may be produced against him. Taken under the Marion bail and committal statutes, Sylvia Woodcock's statement could not be admitted pursuant to the Marion statutes because it was unconfronted. The defendant had not been brought before the examining. This is all case law. Not just that, it's actually historical context. Had been brought before the examining magistrate, and defendant had not been brought before the examining magistrate, and the prisoner therefore had no opportunity of contradicting the facts it contains. Thus, the statements were admissible only if the witness apprehended that she was not in a state of mortality, as would inevitably oblige her soon to answer before her Maker for the truth or falsehood of her assertions. Depending on the account one credits, the court either instructed the jury to consider the statements only if Woodcock was, in fact, under the apprehension of death. Apprehension of death. English Reporter citation, or determined for itself that Woodcock was quietly resigned and submitting to her fate, and admitted her statements into evidence. This is from 1803. Citation. Many other cases excluded victim statements when there was insufficient evidence that the witness was aware he was about to die. The state and the dissent wrote that common law authorities justified the wrongful procurement rule by invoking the maxim that a defendant should not be permitted to benefit from his own wrong. That's quite true. Not sure. Okay, now hold on. The jury already convicted him for murder, rejecting his claim of self-defense. So that's why. But it was in that case that this testimony was given, and that's what the appeal's about. So it's tough. This is tough. If a witness was detained and kept back from appearing by the means of procurement, testimony would be read because the defendant shall never be admitted to shelter himself by such evil practices on the witness, that being to give him advantage of his own wrong. But as the evidence amply shows, the wrong and evil practices to which these statements referred was conduct designed to prevent a witness from testifying. The absence of a forfeiture rule covering this sort of conduct would create an intolerable incentive for defendants to bribe, intimidate, and even kill witnesses against them. There is nothing mysterious about the court's refusal to carry the rationale further. The notion that judges may strip the defendant of the right that the Constitution deems essential to a fair trial on the basis of a prior judicial assessment that the defendant is guilty as charged does not sit well with the right to trial by jury. It is akin, one might say, to dispensing with a jury trial because the defendant is obviously guilty, citing Crawford. Not only was the state's proposed exception to the right of confrontation plainly not an exception established at the time of its founding, it is not established in American jurisprudence since the founding. American courts never, prior to 1985, invoked forfeiture outside of the context of deliberate witness tampering. In 1987, this court approved a federal rule of evidence entitled Forfeiture by Wrongdoing, which applies only when the defendant engaged or acquiesced in wrongdoing that was intended to or did procure the unavailability of a declarant as a witness. And that gives the federal rule of evidence 804b6. We have described this. This is the legislative history in U.S. since founding, whereas prior it's at or before founding. We've described this as a rule which codifies the forfeiture doctrine. Davis v. Washington, 2006 is the citation for that quote. Every commentator we are aware of has concluded the requirement of intent means that the exception applies only if the defendant has in mind the particular purpose of making the witness unavailable. The commentators come out this way because the dissent's claim that knowledge is sufficient to show intent is empirically not the modern view. In sum, our interpretation of the common law forfeiture is supported by 1, the most natural reading of the language used in the common law, 2, the absence of common law cases. So here's like another analysis of statutory interpretation. It wasn't enough that this predates the Constitution. We're now saying the most natural reading of the language used in common law, the absence of common law cases admitting prior statements on a forfeiture theory, and when the defendant had not engaged in conduct designed to prevent a witness from testifying. And 3rd, the common law's uniform exclusion of unconfronted inculpatory statements by murder victims, except testimony given with awareness of impending death, in the innumerable cases in which the defendant was on trial for killing the victim, but was not shown to have done so for the purpose of preventing testimony. A subsequent history in which the dissent's broad forfeiture theory has not been applied. The first 2 and the last are highly persuasive. The 3rd is, in our view, conclusive. The dissent closes by pointing out that a forfeiture rule which ignores Crawford would be particularly helpful to women in abusive relationships, or at least particularly helpful in punishing their abusers, not as helpful as the dissent suggests, since only testimonial statements are excluded from the Confrontation Clause. Statements to friends and neighbors about abuse and intimidation, and statements to physicians in the course of receiving treatment would be excluded, if at all, only by hearsay rules, which are free to adopt the dissent's version of forfeiture by wrongdoing. So this is a carve-out from this. In any event, we are puzzled by the dissent's decision to vote its perforation to domestic abuse cases is the suggestion that we have one confrontation clause, the one the framers adopted and Crawford described for all other crimes, but a special improvised confrontation clause for those crimes that are frequently directed against women, question mark. Domestic violence is an intolerable offense that legislatures may choose to combat through many means, from increasing criminal penalties to adding resources for investigation and prosecution, for funding awareness and prevention campaigns. But for that serious crime, as for others, abridging constitutional rights and criminal defendants, is not in the state's arsenal. Domestic violence context is, however, relevant for separate reasons. Acts of domestic violence often intended to dissuade a victim from resorting to outside help and include conduct designed to prevent testimony of police officers or cooperation in criminal prosecutions. Where such an abusive relationship culminates in murder, the evidence may support a finding that the crime expressed the intent to isolate the victim and to stop her from reporting abuse to the authorities or cooperating with criminal prosecution, rendering her prior statements admissible under the forfeiture doctrine. Earlier abuse or threats of abuse intended to dissuade the victim from resorting to outside help would be highly relevant to this inquiry, as would evidence of ongoing criminal proceedings at which the victim would have been expected to testify. The state courts in this case did not consider the intent of the defendant because they found it relevant to application of the forfeiture doctrine. This view of the law was error, but the court is free to consider the evidence of the defendant's intent on remand. The judgment of the California Supreme Court is vacated. Thomas concurs, Alito concurs, Souder and Ginsburg concur in part, Breyer, Stevens, and Kennedy dissent. And I would read all of these dissenting opinions. It's only a page and a half, and hopefully can't be as difficult as the majority. Thomas, I write separately to note that I adhere to my view that statements like those made by the victim in this case do not implicate the confrontation clause. Nonetheless, in this case, respondent does not argue that the contested evidence is non-testimonial. The court below noted no dispute on the issue, and it is outside the scope of the question presented because the court's opinion accurately reflects our confrontation clause jurisprudence, where the applicability of that clause is not an issue. I join the court in vacating the decision below. Alito, I join the court opinion, but I write separately to make clear that, unlike Justice Thomas, I am not convinced that the out-of-court statement issue here fell within the confrontation clause in the first place. So I'm not sure why he concurred then, but Souder and Ginsburg concur in part. The historical record, as revealed by the exchange, simply does not focus on what should be required for forfeiture when the crime charged occurred in an abusive relationship or was its culminating act. Today's understanding of domestic abuse had no apparent significance at the time of the framing, and there was no example of a forfeiture rule operating in that circumstance. She's completely wrong. She cannot. Her, female, cannot put herself into the framer's shoes because none of them are females. And for that very reason, her entire proposition is inaccurate. So, and there is no early example of the forfeiture rule operating in that circumstance. Examining the earlier cases and commentary, however, reveals two things that count in favor of the court's understanding of forfeiture when the evidence shows domestic abuse. The first is a substantial indication that the Sixth Amendment was meant to require. The framers considered their wives to be property, so domestic abuse didn't exist. It wasn't thought about because it didn't exist. Criminal offense at the time was called harshness or something. Harsh, vile, blah, rude, I forget. Some degree of intent to thwart the judicial process before thinking it reasonable to hold the confrontation right forfeited. Otherwise, the right would be practical terms boiled down to a measure of reliable hearsay, a view rejected in Crawford v. Washington, 2004. The second is the absence from the early material of any reason to doubt that the element of intention would normally be satisfied by the intent inferred on the part of the domestic abuser in the classic abusive relationship, which is meant to isolate the victim from outside help, including the aid of law enforcement and the judicial process. If the event for admissibility shows a continuing relationship of this sort, it would make no sense to suggest that the oppressing defendant miraculously abandoned the dynamics of abuse the instant before he killed his victim, say, in a fit of anger. The court's conclusion thus fits the rationale that equity requires and the historical record supports. Oh. So the intention to kill someone to make them unavailable versus the intention to kill someone in a fit of rage, of jealous rage. I'm saying that out loud because the forfeiture, I'm assuming, was not contemplated as part of the confrontation clause as an exception at the time of framing. I think that they've established that. And the forfeiture clause requires intent to make someone unavailable, which we're doubting was in the facts here, I'm guessing, which is why we can't have the statement go. But they did have the statement go to convict this person. And now on appeal, they're trying to get a ruling that it shouldn't have been entered. Right, because forfeiture exception doesn't have any authority. So it violated his rights and should be pulled back. And that's what the justices so far are agreeing. The forfeiture is this man-made post-Constitution concept that the founders didn't want to prevent a defendant from their right to confrontation of the witnesses against them. So Breyer, Justice Stevens, and Kennedy joined dissenting here. And they're just going to sob and cry about domestic abuse, I can tell right now. Now they're talking about motive and intent. And I think I've got a handle of this now without reading why people would disagree with it.